case is in the matter of the estate of Lorine Mueller, case 127532 from Sedgwick County. If counsel could please come forward and announce your appearances.
May it please the court, Michael Jelka appears on behalf of Margot Loop.
Don Peterson on behalf of Gary Mueller.
May it please the court, Clark Grant on behalf of Cheryl Mueller.
Whenever you're ready, Mr. Joker. Would you like to reserve any time for rebuttal?
Yes, Your Honor, I'll reserve 5 minutes.
Granted.
May it please the court, members of the court, I represent Margot Loop, the appellant in this case. The Kansas Supreme Court holds that when an heir owes a debt to the estate, the amount of that debt plus accrued interest must be set off against that heir's distributive share of the estate. In this case, and it's in the record at Record Volume 6, page 56, the estate holds a $340,846.52 judgment against Cheryl Mueller. Our position here is that the district court erred in not following precedent and not applying the set-off against Cheryl Mueller. In our view, this case presents the mirror image of the Wernette case. Cheryl Mueller occupies the same position in this case as did Clifford Fry, the nephew in the Wernette case. Both owe a debt to the estate. In Clifford Fry's case, it was a $15,000 promissory note. In this case, it's the $340,000 judgment. And both present, in our view, the same legal argument, namely that we have a legal defense to collection, and therefore a set-off can't be imposed against us. And in Wernette, the Kansas Supreme Court rejects that argument and holds that set-off is an equitable doctrine, and it differs from collection and is not defeated by a legal defense. In the Kansas Supreme Court's view, the amount of the indebtedness of an heir is regarded as property of the estate that is already in the hands of that heir and therefore must be set off.
Counsel, before we get into the Kansas law, can you talk to me a little bit about the district court? Its judgment seems a little bit unclear, but is it correct that the district court just pretty much relied upon the Nebraska law?
That seems to be what the court did. I mean, to the extent that the court is relying upon Kansas law, our view is it's misinterpreting Wernette. But one could read this a journal entry from Judge Rumsey to say that he's applying Nebraska law, which we think is fundamentally wrong here. We think in a Kansas probate case, when we're talking about the disposition of the personal property of the decedent, that a Kansas court applies Kansas laws.
And is that because that's a procedural mechanism?
No, it's a substantive. I think every state, and I'm not clear about procedural versus substantive in this context, is, in our view, the law of every state that when distributing personal property, the court applies the law of the domicile. We think the construct of every state is the law of the domicile controls the disposition of real property in that state and personal property wherever it's located. And in an ancillary probate, in this case Nebraska would apply Nebraska law. So we think it's incorrect for a court to rely upon Nebraska law to the extent that's what Judge Rumsey is doing here. And I would point out here that the Nebraska court very explicitly stated in its opinion, here on page 27 of its opinion, that we in Nebraska are not adjudicating this personal property which is under the jurisdiction of Kansas. Kansas probate court will address that, and it's implicit in our view in that is that the Kansas court does so applying Kansas law. So the procedural context of this case does matter here. We're in Kansas. or distributing the personal property of the decedent, and our view is that you apply Kansas law. Now, it seems to us the starting point for the court here is this $340,000 judgment a debt owed to the estate?
And counsel, before you get there, can you just help me a little bit with the chronology? I know you're relying upon the language in the settlement agreement, the confession of judgment. Is there anything in the will itself? Was the will executed before those documents?
Yes, the will was executed in 2007.
And it just makes the general distribution, nothing particular about the confession of judgment. Obviously.
It's 9 years prior to the judgment.
Correct, but none of the underlying facts that later gave rise to that were mentioned. I mean, everybody's treated the same.
Correct.
Okay, thank you.
Correct.
Got it.
So we think that the first question here is this $340,000 judgment a debt owed to the estate? And our answer to that must be yes. This judgment has been upheld by the Nebraska court, has been affirmed by the Nebraska Court of Appeals, and our view is that under the full faith and credit clause, the court must recognize and uphold this judgment. And after all, this judgment is no different than the $15,000 promissory note that Clifford Fry executed.
Well, it might be different to the extent that there's that language in the settlement agreement that says the estate shall not seek to collect the confession of judgment. I mean, I don't know that they had that in this comparable case you're talking about.
Well, let's be clear on this point, Your Honor, that the settlement agreement also says it shall not be collected, but it shall not be forgiven.
Yes.
And so it shall not be forgiven. So it seems to us that what Cheryl Mueller is trying to do is simply to make this judgment just pretend it doesn't exist and make it go away, but the court cannot do that. And the mere fact that it's not collectible does not mean that it can't be subject to set-off, because the Warnett case itself makes that point that Clifford Fry's $15,000 promissory note couldn't be collected, but that didn't bar a set-off to the extent of Clifford Fry's distributive share of the estate. And let's also be clear here that this settlement agreement doesn't say anything about set-off, one way or another. It seems to us that the court has to reconcile the two aspects of that settlement agreement. It says it shall not be collected, but it shall not be forgiven. And it further is our view that the way you have to look at this is Nebraska applies its law to the assets under its jurisdiction, and a Kansas court applies Kansas law to the assets under its jurisdiction.
Why should we wholly disregard the seeming intent of the parties stated that Nebraska law should govern?
Well, first of all, because it cannot make the judgment go away, Your Honor. And we've, by the way, addressed this in the first 3 pages of our reply brief. So to the extent I'm not able to articulate this as well as I should, we think we've articulated it in those 3 pages. And it seems to us that Nebraska law, it can't say that this judgment is therefore goes away. And further, I want to emphasize again the language of the settlement agreement, which says this judgment shall not be forgiven. We think the court has to give effect to that phrase here. Otherwise, this judgment just becomes meaningless, which this court cannot do under the holding of Warnett. Now, let me be clear about this here. The estate here is not suing Cheryl Mueller to collect anything. Maybe Nebraska law would apply if that were the case, but that's not what's going on here. There's a distinction here between offensive efforts to collect versus defensive efforts to set off. And here, we're in the latter category. And in that circumstance, it's our position that Kansas law is going to control, not Nebraska here.
How do these two statements go together to say the estate shall not collect the judgment, but the judgment shall not? It doesn't even say but. Just
Sure.
Period.
Sure.
The judgment shall not.
It says that the estate can't go on offense and seek to get the money from Cheryl Mueller, can't seek to pursue a $340,000 judgment against her. But in the event that Lorine Mueller dies and there's money in the estate, under Kansas Supreme Court precedent, this $340,000 is considered to be an asset of the estate that's already in Cheryl Mueller's hands, and to that extent is satisfied. So in our view, Cheryl Mueller actually did receive a benefit from this $340,000 judgment.
You just don't want her to double dip.
Exactly, Your Honor. I mean, first of all, she avoided the public humiliation of a trial to have her thievery exposed in public. Second, she couldn't be garnished. And third, if Lorine Mueller lived and was in a nursing home for the last several years of her life and spent every penny she had, Cheryl Mueller would be off the hook. The estate couldn't have done anything to her. So the idea that she didn't receive a benefit from this agreement is not actually correct here. Now, I do want to leave some time here for my colleague, Mr. Peterson, to address the court. But I do want to briefly mention, and we have discussed this in our brief, our reply brief actually, this argument concerning the language in the will and the choice of law provision in the will. And in brief, we urge this court to follow the reasoning that is articulated by the New Hampshire Supreme Court in re Estate of Dow, which we think presents the same issue that this case presents. And to summarize that holding, it is, we believe there's a distinction here between rules of construction on the one hand, which a testator can put in their will to what state's law to use, and on the other hand, a state's substantive law. And our position here is the law of set-off falls in the latter category, and therefore the reasoning that's espoused by the New Hampshire Supreme Court should be followed by this case as well.
Do you have a cite for that handy?
Yes, Your Honor. It's in our reply brief, and let's see, the citation is 174 New Hampshire 37, 260 A 3rd 1. It's a 2021 case cited at page 5 of our reply brief. Okay, Your Honor, I want to give Mr. Peterson a chance to address the court. Thank you.
Thank you. Let me start by saying that I agree with everything that Mr. Jilka just said. Second point is the main difference, the main additional thing that my client has to say is that he never signed the settlement agreement at all. He refused to sign it. So he's in a slightly different posture. I want to talk about two of the questions that you each asked a different question, but they're related, and I just want to briefly chime in on those. You asked about, is the reason that the rule in the Wernette case is procedural, is that why? And Mr. Jilka sort of begged off of that just a little bit, and I think, let me comment about that. In the Dow case, what they were looking at was the restatement section that says a party who creates a will can designate the law of the jurisdiction to construe the will. And by negative implication, you don't get to choose the substantive law that applies. You can choose the law that will be applied to construe it. And what the Dow court held was that the rule in play in that case was a substantive rule of law. Okay? And we've been arguing, I think, that here the Wernette rule is a substantive rule of law. But the truth is our position doesn't depend on that. The crucial point is that it's not a rule of construction. And you can tell that there's no rule of construction about the will in play here because nobody's quoting from the will. Let's get to your point, okay? Nothing in the will talks about what should happen here. So what the will means is irrelevant because it just doesn't address this question. So there are no rules of construction in play. So the crucial question is, why did Judge Rumsey apply a Nebraska rule about set-off? And it was, I guess, because the Nebraska court had done it and he was just following what they did. But the answer is he was wrong to do that because the rule in play in Nebraska that the court relied on, their set-off statute, 3024-101, is not a rule of construction. It can't be applied here under the restatement. Thank you.
May it please the court. First of all, I want to thank you for the opportunity to be here today. I'm a Nebraska attorney and here arguing by your permission, so thank you for that. Both of the parties have accused each other of getting the cart before the horse. That's found in opposing counsel's brief as well as my own. And I suggest that Ms. Loop and Mr. Mueller got the cart before the horse because they wanted to go straight to the rules in Kansas on disposition of property, and they don't want to look at the parties' agreement that was entered into regarding the confession of judgment. And so what I would suggest to the court today is that the starting point of this case is the settlement and mutual release agreement. We can't determine the outcome of this case without studying that document.
Is there relevant language in there that's substantive we should look at other than this clause we've discussed, the two sentences?
The two sentences, which two?
Meaning the estate shall not seek to, you're talking about a settlement agreement. The estate
Yes.
shall not seek to collect the confession of judgment. The confession of judgment shall not be forgiven.
The settlement agreement is silent. It doesn't contain the word set off. It only contains the two lines that you referred to are the only lines that speak to this issue of ultimately of the issue of set off. But more importantly, the settlement agreement entered into by agreement of the parties, with the exception of Mr. Mueller, which I'll get to that in a moment. The settlement agreement itself indicates that if there's a dispute about how it's to be construed, then only Nebraska law shall apply and only Nebraska courts shall determine how it applies. And fortunately, we've been, it was a long road to get to where we are to get a decision from a Nebraska court, but we finally got there. And it's pointed out in opposing counsel's brief that we took several different avenues of trying to get a ruling on the merits on this issue of set off in Nebraska, and it didn't work on two occasions. I was actually in the Nebraska Court of Appeals twice on this case, but we finally went back to the probate court in Platte County, Nebraska, and got a dispositive ruling on the merits of the issue of set off. And that, by the way, is the first time the set off issue has ever been specifically addressed in Nebraska with regard to that, to Section 30-21 101, I believe, or 24-101, excuse me.
Did it address the set off as an equitable issue?
Well, it addressed what the judge did in the probate court in Nebraska is strictly followed the statute that we have in Nebraska and in Nebraska's probate code on this issue of set off. Nebraska, like all other states, recognizes the right to set off, but unlike some states, such as Kansas, Nebraska law provides that if you have a defense to the action that creates the obligation, then you're permitted to present that defense to defeat the set off. And that's the difference between the law in the two states. But the parties agreed in the settlement agreement that the law of the state of Nebraska was going to apply to construe the effect of the judgment. So we have to back up and look at the judgment itself and say, all right, is this just an ordinary debt that can be used as a set off in any state, or are there some special strings that were attached to that judgment? And lo and behold, there was a lot of strings attached to that judgment, and specifically that the decedent, through her conservator, who was Margot Loop, agreed that the laws of the state of Nebraska would apply. That includes the laws of probate in the state of Nebraska. And you just can't get around that. So we don't have a debt in the sense of a normal debt that doesn't have, like I say, some strings attached to it. This was a very unique circumstance. The settlement agreement was arrived at after several years of litigation. And I was involved in it, and co-counsel here in Kansas wasn't, of course, because all of this occurred in the state of Nebraska as part of Lorine Mueller's conservatorship action that had been pending since 2014.
And I guess that's kind of where our confusion is coming in. You're saying that there were certainly strings attached. What are those strings?
The estate shall not collect. That's the main string. The sentence...
It doesn't end there.
You're right, and let's talk about that. The judgment shall not be forgiven. And I guess I can tell you that the reason that language was added, it wasn't my idea, but it was Margot Loop's attorney's idea. And the final selling point to the settlement agreement from them to us was that if we put that language in, shall not be forgiven, then we can file a tax return for Lorine Mueller and claim a loss on her taxes to offset some capital gains that they knew were going to have to be paid as a result of selling some farm ground that was needed in order to support Lorine Mueller's care in the nursing home.
Is there anything in the record to support that interpretation? Of that
Probably not in the particular record before this court at this point in time, but I can tell you that that was exactly the reason it was done. And you're right, it's probably not specifically in the record, but I would submit to your honor that it's not necessary to be in the record because that line doesn't change the shall not collect line, and it doesn't change the fact that the Nebraska court has now determined the effect of that judgment as it has to do with the issue of set-off. And again, the parties agreed that Nebraska law would apply. So the shall not be forgiven clause, I think, is a red herring at this point because, in my opinion, we have to, and I guess we all agree that Nebraska law and Kansas law is different on the set-off issue, and now we have a judgment arising out of this very same case that says, yes, Nebraska law is different. And not only that, it's not only different, but it applies, in this case, to bar set-off. And that is true whether we're talking about disposition of assets in Kansas, Alaska, or any jurisdiction in the world, in my opinion.
Let's assume that we disagree and find that Kansas law applies and that we're going to view the offset as an equitable matter. And we're just looking at the language of the settlement agreement, even if we don't look at the language about forgiveness or lack of it, and we focus on the estate shall not seek to collect the confession of judgment. We're all lawyers. Isn't collection that it's talking about when you go forward and try to get that money back from that person in the form of a lawsuit?
I think collection is can be broadly defined as I have a judgment, now I have to go collect it. I have a lot of judgments in my files at home that have not been collected. Right. So no,
you're taking affirmative legal action to go collect it. Right?
Exactly, a whole separate proceeding in some instances.
But that's not the same as an offset, is it, sir?
I agree that there's a distinction there, but I don't think the distinction has merit in this case. Let's look at the equity of it, okay? So in the Wernette case, the successor nephew owed some money to his uncle, I believe it was, or whatever the relationship was, and then nothing was really said about it. The difference here is that in this case, the decedent, through her conservator, who is one of the parties to this case that signed the settlement agreement, said, well, we're going to take this judgment, but we promise never to collect it. Well, do you think that had something to do with the inducement of my client to sign the settlement agreement and to sign off on the judgment? It absolutely did.
Correct, but I'm sure they did enter into it, but if you're talking about the equities of the thing, your client greatly benefited by the confession of judgment to the tune of she didn't have to pay back $340,000 or go through a trial. She got the benefit of that money that she had obtained from the estate of the decedent. And how is it equitable to let her then double dip?
I would submit, Your Honor, that if you read the settlement agreement as a whole, you will find a clause that says we do not admit any actual liability.
I saw that.
So there's a number out there that my client totally disputes. In fact, she disputes that she did anything wrong, And the only reason that we came to this settlement was to stop the litigation. You know how expensive that is. And it was our perception that agreeing to the judgment would have no negative impact ever because they agreed not to collect it. And then finally, everybody got the benefit of the tax consequences of the shall not be forgiven line.
So isn't that all the benefit to which she's entitled then?
The benefit of, well, no, because what the parties, Margot Loop and Gary Mueller want to do now is deprive her of the benefit of that agreement. I promise I won't collect. And I know there's a difference between collection and an affirmative defense. But I would submit to you, and I heard the words thievery. Well, she stole money from the estate, and so she already has that money. If we would have gone to a full trial, Your Honor, I don't believe that the Margot Loop and Gary Mueller would have been able to prove up those allegations. But we were put in a spot. You know, at some point, the cost of litigation has to be taken into account. At some point, the benefit that can result from the judgment has to be taken into an account. And most importantly, the fact that they promised not to pursue it. The estate promised not to collect. Well, how is that really different than an offset? Isn't the state really actually collecting the money? If it says, well, no, we're not going to collect it against you, Cheryl, in the estate's not going to do that. Well, who's doing it if the estate's not doing it? And so I don't believe that Cheryl is double dipping at all. I think what we're trying to do is preserve the agreement that was made between the parties. And I want to address the issue of parties. Gary Mueller says, well, I didn't sign the settlement agreement. Well, he didn't need to sign the settlement agreement at the time because it was signed by Lorine Mueller's court-appointed conservator, the sister of Gary Mueller, and that was Margot Loop. So in terms of enforceability, you didn't have to have all of the heirs line up and sign that settlement agreement because it was signed on behalf of the actual decedent. So to say that all of the other heirs would have been necessary parties is completely erroneous. I do want to mention just briefly the issue of the language in the will itself that says, I want Nebraska law to apply. And the other side discounts that by saying, well, that only has to do with rules of construction and not substantive law. And what's cited is the New Hampshire case, the Dow case. I looked to see if I could find a similar Kansas case, and I found none. I found no similar case in Nebraska, and I would submit that the Dow case is an outlier and shouldn't be followed by this court. What I would ask the court to do is look at the restatement law that I cited and the other law that was cited in my brief and see whether that really says it only applies to rules of construction. If you look at the language that Lorine Mueller applied in the will itself, it says anybody that's going to take and benefit from this will is subject to the law of the state of Nebraska. Now, can it be said any plainer than that? And is she talking about rules of construction, or is she talking about the Nebraska probate code? I would submit that Lorraine's will makes reference to the Nebraska probate code and not just some esoteric rule of construction that we might have for contracts and wills. The bottom line here is that the parties made a deal, and the deal was that Cheryl would reluctantly agree to this large judgment to settle a lawsuit that had been pending for 2 years, and in exchange for that, Lorraine's estate agreed not to pursue collection of the judgment. At that point in time, I thought the matter was closed. I didn't think we'd ever see see that judgment again. But the very year that she died, there was a motion filed in the probate court here in Kansas seeking to have the judgment in Nebraska certified and filed in Kansas and actually collected against my client, completely contrary to the agreement. And I see that my time is up. Have any other questions? Thank you.
Thank you very much, Mr. Green. You have 5 minutes remaining for rebuttal.
Mr. Jilka has kindly agreed to let me speak on this rebuttal. Yeah, I'll leave him a little time to chime in, but I want to take counsel up on the offer to look at the authorities he cited on whether a will's choice of law can do more than just simply address construction. And if we look at page 10, the first thing he cites is from Amjur, 16 Amjur 2nd, Conflicts of Law. If the testator specifically or definitively implies what law he intends shall govern, the will ordinarily be construed in accordance therewith. The Conflicts of Law section, Conflicts of Law 2nd, 240, it's literally titled Construction of a Will. The comment E that they quote begins, the forum will give effect to a provision in a will that it should be construed in accordance with the rules of construction. And I could go on, but the point is, a will is not a contract. The state has an interest in how the property within its jurisdiction is addressed when someone dies. It's different. It's not contract. They cite a lot of contract cases. Those have nothing to do with this case. Construction. The Dow case is the only case we could find that specifically on point addresses this argument, where you have a will that chose the law of a certain state, and a court had to decide when you're dealing with substantive legal provisions, do the substantive law of the state that's referenced in the will apply, or is it the substantive law that would apply anyway? And the Dow court said these choice of law rules specific to wills talk about construction, and the issue in this case is not about construction. And just as there, the issue here is not about construing the will. Counsel spoke for a long time and didn't quote one word from the will. Quotes from the settlement agreement. That's important here. Why? Because we start then with a Kansas probate about Kansas property, and Kansas substantive rules apply. That's what we learned from the restatement and from Dow. At that point, my client says, hey, there's a judgment in Nebraska. And by the way, it's volume 6, page 56. It's a single page. It's just a judgment. It doesn't say I'm a redheaded stepchild judgment. I'm a judgment. Here I am. So we say, under the Kansas substantive law that applies here, we get set off. They come in and make a defense to that. And they say, yeah, but there's an agreement. And that agreement says something about Nebraska law. Well, that can't make Nebraska substantive law apply to the probate. Some agreement that the parties entered into. The probate action, the law that's applicable there is already been decided effectively, right? You've got a will, you've got Kansas property, you can construe the language of the will subject to Nebraska law, but Kansas substantive law applies. And so when a party comes in with a defense and says, well, wait a minute, but I'm relying on a contract, and that says they won't collect, and so I don't think you... Well, first of all, that isn't going to change the substantive law applicable in the probate, one. And two, it's a defense. It's just fundamentally a defense to a judgment. And when you apply Kansas substantive law, that's Warnett, we don't care whether you have a defense. It's a set-off in Kansas. Whatever defense you had is irrelevant. Do you have any other questions? Thanks.
Members of the court, let me make two brief points about opposing counsel's presentation. First, with respect to the language in the settlement that said this judgment shall not be forgiven, we heard an explanation today giving us all sorts of explanations about tax reasons that are not in the record. So I would submit to the court that the court cannot just simply take Mr. Grant's statements at face value because they're not in the record. The second thing I want to address here is opposing counsel's statement that we would have prevailed if we had gone to trial and this $340,000 judgment would not have been entered against us. But that doesn't change the fact, Your Honor, that this judgment is final. It's valid. It's been litigated in Nebraska, in which the other side attempted to overturn it. It went up on appeal to the Nebraska Court of Appeals. The Court of Appeals in Nebraska affirmed the judgment. So the court has to take that as established fact. It can't engage in a revisionist history of what may have happened. The judgment is a fact, and a prediction about what might have happened is not a proper basis for this court to ignore that a judgment is in effect and must have legal consequences in the Kansas probate, and we think those consequences are dictated by the holding of In re Estate of Ornette. Thank you.
Thank you. Thank you to both parties. We appreciate your arguments. They were insightful and will be helpful as we resolve your case. We will take the matter under advisement and issue an opinion as quickly as possible.
Thank you.
Thank you, Your Honor.
Thank you.